Welcome to EU Privacy for All. Today in Session 3 on GDPR, we're going to deal with further use of data, that is to say Article 6.3a. A caveat as usual, the content is directed to non-experts, summarized, and only aiming at informing accountable controllers and processors about their upcoming obligations. We focused already on DPIAs, consent. Let's stress today key points on further use of data. The key provision in GDPR dealing with further use of data is Article 6.3a. For any other purpose than the one justifying the initial collection of personal data, the controller is bound to assess compatibility of this further use, based on 5 criteria. First, any link between the purposes for which the data have been collected initially and the purposes of the intended further processing. Second, the context in which the personal data have been collected. This concretely targets the reasonable expectations of data subjects. Third, the nature of the personal data. Basically, it deals with 2 situations. First, processing of sensitive data or processing of data related to criminal convictions and offenses. Fourth, anticipating the possible consequences of the intended further processing for data subjects. And finally, ensuring that appropriate safeguards are put in place, such as encryption or pseudonymization to mitigate privacy risks. Recital 40 in GDPR is also having an added value that we should highlight. Basically, when a further processing is operated and is deemed as being compatible, no separate legal basis is required. Archiving and using data for the interest of the public, scientific or historical research, or statistical purpose should by default be considered as compatible. In the frame of negotiations between European Parliament and EU Council, a blocking point appeared regarding the further use of data. European Parliament did not envisage at any stage any kind of incompatible further use of data. On the contrary, EU Council added a specific provision, Article 6.4, on incompatible further use of data. Finally, this provision was not retained, and the final draft only envisages a situation in which compatible further use of data will be assessed. What's currently binding and laid down in the directive? In Recital 28, there is a clear statement, whereas the purposes of processing further to collection shall not be incompatible with the purposes as they were originally specified. To make a long story short, no incompatible further use seems to be allowed. Following Recital 29 focuses on suitable safeguards that should be ensured. Those safeguards must in particular rule out the use of the data in support of measures or decisions regarding any particular individual. Basically, no automated decision-making that could have a significant impact on an individual. Finally, Article 6.1b mentions that member states shall provide that personal data must be collected for specified, explicit and legitimate purposes, and not further processed in a way incompatible with those purposes. In line with Recital 28, incompatible further use of data is explicitly excluded. What should accountable data controllers get prepared for? First, using any legal ground provided by Article 6 of the GDPR, for instance, collecting on the basis of consent. Then, assessing compatibility of any envisaged further use of data. Finally, either demonstrating that the further use is compatible or identify a separate legal ground. Recital 40 of GDPR stresses the fact that the controller should be allowed to further process the data irrespective of the compatibility of the purposes in two cases. In first case, when data subject has given consent, or second case, when the processing is based on union or member state law. This seems quite mysterious and blurring because we don't really know today what will be the impact of such a provision. Information of the data subject and its right to object shall be maintained. Finally, a specific example on criminal acts or threats to public security being further used or indicated to public authority should be regarded as being in the legitimate interests pursued by the controller. In this real specific example, there is a caveat. Such transmission made by the controller or further processing of personal data made by the controller should be prohibited if the processing is not compatible with legal, professional, or other binding obligation of secrecy.